Okay, we are live.
Right, good afternoon and welcome to the House Environment Committee. This afternoon, we're welcoming our Legislative Counsel, Ellen Tchaikovsky, back to, I think, walk us through Act 181 and give us some background, current status of Act 250. Welcome.
Yep. Ellen Tchaikovsky, Office of Legislative Counsel. So today, posted on your website under my name. I'm going to start with the brief intro to Act 250, which is going to be a short slideshow. And then I'm going to go through Act 181, which is posted in its entirety. And then also my section by section from last year on Act 181, because walking through the 108, so it's 171 pages, but my part is 120 pages. So it is going to be a long discussion, but I gave you the clip notes, which is what I'm going to primarily stick to in the second half. So I'm going to start with the PowerPoint, and I'm going to share my screen. So, Act 250. I'm so not good with technology. All right. Good. We're good. Okay, so here we go. Okay. So I'm going to do a brief introduction on Act 250, which is the state's land use and development law. It is codified in 10 VSA Chapter 151. And this is a brief review of that statute so that I can give you some context for the changes that were included in Act 181 of last year. Act 250 was enacted in 1970 as the regulatory scheme for large development in the state. And so it is a permitting program for the construction of development. So first, Section 6081 of Title 10 establishes this requirement that no person shall sell a subdivision, commence development, or commence construction of development or subdivisions without an Act 250 permit. So you need to know what the definition of development is and what the definition of subdivision is. And we colloquially refer to these as the jurisdictional triggers or thresholds of Act 250. So to know if you need an Act 250 permit, you have to know if your project is going to meet the definition of development or subdivision. There are quite a list of things under the definition of development. The one that most people hear about, especially in discussions in legislation, are the two that are highlighted there. So the construction of improvements for commercial or industrial purpose on more than 10 acres of land or more than 1 acre of land if the municipality does not have both permanent zoning and subdivision bylaws. I'll talk more about this on the next slide, but this is the distinction that we refer to as being in a 10-acre town or a 1-acre town. If the town has adopted zoning, it's a 10-acre town and therefore requires 10 or more acres to trigger Act 250. The 1-acre town and it hasn't adopted permanent zoning and subdivision bylaws. Only a project located on more than 1 acre of land triggers the need for a permit. Additionally, there has been a lot of discussion about this next bullet point in the last few years. The construction of 10 or more units of housing triggers Act 250. I'll just highlight, so then there's all these other things that are not as common that will trigger Act 250. And then there's the new one that's highlighted at the bottom, the construction of a private road longer than 800 feet or a combination of private roads longer than 2,000 feet. And that doesn't kick in until 2026, and I will talk more about that later. That's what we have been calling the road rule. But in addition to all these definitions of development under Act 250, there is a long list of exemptions that exist in both Section 6001 and 6081. There's also a definition of subdivision. And so that is when a person partitions or divides for the purpose of resale a piece of land into 10 or more lots, if located in a town with zoning. If it's located in a town without zoning, it's 6 or more lots. And if the lots are going to be for public auction, it's 5 or more lots. So here's the brief overview, brief and incomplete analysis. Do you need an Act 250 permit? You're going to construct something. What's the purpose of the development? Is it a commercial development or are you a governmental agency? Are you a municipality, county, state, or public purpose constructing something? Probably you're in the commercial category. If it's a commercial purpose, does the town in which the project is located have permanent zoning and subdivision bylaws? So that's what I already mentioned, the distinction between a 1-acre town and a 10-acre town. The Natural Resources Board, now Land Use Review Board, maintains a list on their website of the towns that fall into the categories. So you can just look that up if you don't know off the top of your head. If it's a commercial project you're seeking to build in a 1-acre town, is your project going to be located on a parcel that has is 1 acre, or let me start again. If the commercial project is in a 1-acre town, is more than 1 acre of land involved? And if it's in a 10-acre town, is more than 10 acres involved? For commercial projects, involved land means the whole tract of land, the whole parcel. So if you're a private entity doing a project for a commercial purpose, is the project you're constructing located on a parcel that's more than 10 acres in a 10-acre town, or more than 1 acre in a 1-acre town? If yes, you will probably need an Act 250 permit. If an Act 250 permit is required, the applicant must demonstrate that the project will comply with the 10 criteria of Act 250. I will again reiterate that there is also a long list of exemptions that was added to by Act 181, so you also may not qualify. And when in doubt, contact the district office and the district coordinator will let you know if you need a permit. If you need a permit, what you need to do is file an application that demonstrates that your project is going to comply with the 10 criteria of Act 250. I think a lot of times these are known as environmental criteria, but I would reiterate that I think half of them are actually criteria that address issues within a community, so they're community-based criteria. For example, criterion 5 asks to look at if there's unreasonable congestion or unsafe conditions in traffic that will be created by the project. 6 and 7 then look if your project is going to have an unreasonable burden on the educational facilities or the governmental facilities in the town. Criterion 9 also is a catch-all that has a lot of different topics in it. But the application will depend on what the specifics of your project are. And so it really will be on the applicant to demonstrate that they have addressed the issues under each criteria in developing their project. I'll also just remind you that Act 181, we'll talk about this more, did create a new criterion 8C, which is forest blocks and connecting habitat. So I'll talk about that more later. So then what happens? An applicant needs to review all those criteria, address them in their permit, and they submit their application to one of the 9 district offices. So Act 250 has a distributed system. It's not fully unified in one state office. There are 9 district offices that coordinate roughly with the counties of the state. And so depending on where your project is located, you go to the local office where your project is. The office is made up of 3 district commissioners that have been appointed by the governor, as well as alternates, as well as some administrative staff and the district coordinator. So the district coordinator is there to help answer any questions that you may have about your application, and then assist the district commissioners in reviewing the application and doing the research related to it. The district commissioners are members who live, members of the community who live in the community. They are essentially volunteers. They receive a $50 per diem payment for their work when they're working on the Act 250 permit applications, but it is a narrow time frame. So it doesn't include all of their prep time and all of their review time when they're working on a permit. So these are members of the community that are not state employees that are working on reviewing the applications. I was going to pull the Act 250 report to see the statistics, but you can hear from the Land Use Review Board on this, but most applications don't have to have a hearing. They'll either be considered a minor application or an administrative amendment to an existing project. And if that's the case, the permit will be issued by the district commission within a matter of weeks. If there is a hearing, because it is a major project, one that may have issues related to the criteria or has there have been concerns raised about in the community, the person bringing the application will attend a hearing with the members of the district commission. It is a less formal hearing. It is not really like going to court. The applicant may or may not have an attorney representing them, and the proceedings don't necessarily follow the strict rules of civil procedure or evidence that a courtroom would. It is intended to be a more citizen-friendly process where an applicant brings their proposal to the district commission and they review it and discuss any issues related to the criteria that need to be addressed. And in those situations, members of the community may join the case as a party, but only if they can demonstrate that they have a particularized interest in the case that only they can represent for themselves. So that is a higher standard than in some other permit cases. And so it does require that they demonstrate and that the commission review that particularized interest. And there's an opportunity to review at the end of the hearing to see if the person actually did have a particularized interest. They are also required at that point to then actually participate in the hearing in order to maintain their party status. At that point, the commission may seek additional information from the applicant or from any of the parties, and then recess the hearing, review all the materials, and then they have the option to approve the application, deny the application, or approve with conditions. And I think the majority do go with approve with conditions. A very small percentage of applications are actually denied. It's less than 2%, I believe, based on the last year's statistics. But if the district commission is going to approve with conditions, the conditions are supposed to be attached to directly mitigate any of the issues under one of the criteria. So if there's some back and forth that happens with the commission with the applicant where they say, okay, we're concerned about soil erosion on part of the site. Is there something let's see if we can get something that we can do to prevent any further soil erosion during the construction and then operation of your development. And then we'll put that in the permit for you to follow as time goes on. Thereafter, the applicant who receives their permit may appeal. If they don't like any of the conditions, they can appeal, or if any of the other parties to the case are unsatisfied with this decision, they can appeal. The appeal goes to the Environmental Division of the Superior Court, and any further appeals go to the Supreme Court. That is the very, very short version of Act 250. There are a lot of other topics, but that's the basic form and structure of how Act 250 operates. I do think you will have the members of the board in at some point who can talk to you more about how some of this stuff works on the ground, but pretty questions based. I am now going to switch to Act 181 unless anyone has any questions on how Act 250 has functioned for the last 50 years. All right. So I've stopped sharing my screen. I am going to be focusing on the section by section summary of Act 181.
Is listed under your name if folks wanted. I think it's actually one of the items. It would be probably best to look at it on your own device because it's all text.
Yes. Yep. So I wasn't going to share because, yeah, and I'll also post it is the full text of the act, which is quite long. So if you want to look at any of the specific language, you can turn to that. Okay. So Act 181 is quite long, and it does a lot of different things. The land use review portions of that bill are 120 pages, and they cover sort of the full range of land use programs in the state. I will walk through. I do hope that you will hear from the Land Use Review Board and the regional planners and the Department of Commerce and Community Development, who are the people who have been working to implement this law. I know that they have made some fun graphics and maps that will be help to visualize some of the things that I'm about to talk about, because some of it is pretty complicated, and this committee did live in this bill last year. So for the new members, if it seems complicated, it is. But this is just the first introduction. I'm sure you will hear from more people in the coming weeks on how this is all working. So the summary, this is the summary document I prepared for the legislature last year with only some brief typos corrected. Broadly speaking, the first handful of sections are updates to the Land Use Review Board, which is the new name of the Natural Resources Board, which is the state entity that oversees Act 250. There are some changes made to small parts of Act 250 that I will walk you through, but then the middle section is a transition for Act 250 to switch to a location-based jurisdictional system. For the last 53 years, as you've seen in those prior slides, Act 250 jurisdiction was based on whether the project met the definition of development, which will remain to be true, but it was based on the size of the parcel it was located or the type of project it was. This is switching it now to, where is it located in the state? Is it located in an area that has been identified for growth and development? It will have less Act 250 oversight. Is it located in an area where there are critical natural resources that need protection from development or oversight during development? There is more Act 250 regulation there. And then most of Vermont will be sort of in the middle and have less changes, but this is setting up a system where there are 3 tiers for what level of Act 250 oversight applies. Then the bill moves into changes to the regional planning process. Currently, all the state is divided into 11 regions that are overseen by the regional planning commissions, and each region has a plan adopted for that region. But some of the terms that they've been using have been inconsistent, and so this brings consistency to all the plans so that they're all using the same terms, and then those plans are then going to be used in the location-based jurisdiction system so that as the new tiers are developed, all the regions of the state are using the same language to identify and designate the areas of the state that fall into the jurisdictional areas. Then there's a section on municipal zoning related to changes primarily related to housing. And then the last section of the bill on my part is related to updates to the designated area program, which also so we have like Act 250, regional planning, and the designated area program all sort of work together under this system now. So that's the high level of where we're going. But turning to the summary, Section 1 of Act 181 created a statutory purpose section for Act 250. It included references to the capability and development plan, the municipal and regional planning goals, and the 30 by 30, 50 by 50 goals that are in statute already. So it's all bringing them into what the purpose of Act 250 is. And then it does also referencing housing and equitable access to infrastructure. Section 1A is then a session law purpose section, which talked more about those things, but also that Act 250 needed to be updated in the face of climate change, and that changing the structure of the board would help strengthen the administration of the Act 250 program. Section 2 then gets into the changes related to the board. So it amended the statute and changed the name of the board from the Natural Resources Board to the Land Use Review Board. So the Natural Resources Board for the last period of time was made up of 5 members. The chair was a permanent full-time position, but the other 4 were sort of like the district commissioners in that they only received per diem payments when they worked on Act 250 matters, and that was once a month-ish. And so this amendment changed that so that it was 5 full-time members, and they are full-time staff of the state. They're state employees, and the governor is still the one appointing all 5, but it did create the Land Use Review Board Nominating Committee, which I'll talk about more in a moment. It expanded the type of skills sought for the members of the board. And they have staggered 5-year terms with no alternates. Members can seek reappointment. They're removable only for cause. And so this really is changing it from having a 1 full-time board member to 5, so that there are more people part of the oversight of the agency. Section 3 created the Land Use Review Board Nominating Committee. And so previously, for the board members, it was only the governor appointing members of the board. Now this adds a new structure where a vacancy is posted, and the Land Use Review Board Nominating Committee seeks applicants that meet the requirements for the positions. It's made up of 2 members of the House, 2 members of the Senate, and 2 members of the executive branch, with 1 being from the Department of Human Resources. They then review the applications that are submitted and interview applicants, and then submit to the governor a list of names of qualified applicants from which the governor can select. So this is the same structure that's currently used it's modeled after the Judicial Nominating Board, and which is how the Public Utility Commission is appointed. And it's modeled after the Cannabis Control Board, who also has a nominating committee that submits names to the governor. And that process took place this fall, with the process playing out. And so the new board has actually been appointed. Section 4 is the general rulemaking provision for Act 250, and it updates that to direct the new board to adopt rules or issue through guidance the process for approving regional plans and regional maps. And so that is one of the new tasks that you gave them, and I'll talk about that more in a moment. But they can do it by rules or issued by guidance, which is a quicker process than rulemaking. Section 5 updated the powers of the board. So it changed the name of the board here and gave it all the powers it currently does have. But it also added that the board will now review regional plans and their maps and review applications for Tier 1A areas, which is part of the location-based jurisdiction system. I'll talk more about that later. So in my summary document, there are a few notes for the people who had been following this bill, because it was a very long process with lots of plot twists in it. And so for most of the bill last year, if you were following it, it originally gave the board the authority to hear appeals of Act 250 permit decisions. But there's a note in here that says that provision was removed. And so appeal of Act 250 permit decisions and jurisdictional opinion decisions still remain going to the Environmental Division of the Superior Court. But there is a study of that in Section 11A that I'll talk about in a minute. So the new board's new authority is only review and approval of regional plans and review and approval of Tier 1A areas. Section 6 gives the board authority to hire additional personnel, and it also requires to hire permanently the executive director. They did currently have an executive director at the board, but that position had been vacant for a number of years. And so this is requiring that be a permanent position. Section 7 shifts the burden of who provides notice when there's an application. So previously, an applicant had to provide notice of its application to all the required parties, but now the district commissions are going to do that. And then it also is this new provision where applicants are required to post a sign on their property stating that the property has applied for an Act 250 permit, which is similar to the zoning signs that people post. Section 8 allows district commissions to require self-certification for compliance with their permit conditions. That was something they sort of already had the authority to do, but this was clarifying that. Section 9 establishes the filing fee as $295 for a Tier 1A application and a regional plan map approval application. Those fees will not cover the work required to review those applications, but this is the current amount for filing fees with the state court system, and so it was set to match that. And the people applying for these, by the way, Tier 1A areas will be by a municipality, And the regional plans will be by the Regional Planning Commission, so it's more of an acknowledgement of there will be some work required to do this review for them. Section 10 is an appropriation. So it created the 4 new board members for the board, but it also added 1 new staff attorney position for the NRB, and it appropriated money for the half year so that that attorney could get started. It does look like they've hired a new attorney, so I believe they now have 3. Section 11 was the transition of the board. So the governor needed to appoint the new board members by January 1, 2025, and he did. There are 5 new board members. And then it transferred all the personnel under the NRB to the LRB, LURB. And there's revision authority, so I've already started changing the name in some of the statutes, but I don't think we got very far. So that'll happen next year, where I'll change all the references to the board. And then section 11A is an appeals study. So the board has to look at whether or not the Act 250 permit appeals should be reviewed by the board instead of the court. For those who weren't following this last year, previously Act 250 appeals did go to the board, but about 20 years ago, the appeals moved to the environmental division of the Superior Court, and there have been questions about what should be the entity that actually hears appeals. And that report is due next January. Next, the next handful of sections relate to forest blocks and habitat connectors. So section 12 added some new definitions related to this, and section 13 created the new criterion 8C, which requires applicants to not have an undue adverse impact on forest blocks and habitat connectors if they're located within or partially within a forest block or habitat connector. If there's one on the property, they will not have to address that. If it would result, they have to avoid, minimize, or mitigate the effects. And that'll be described in the rules related to how this would happen in rules adopted by the board. And section 14 sets out the rulemaking process for what the board has to do in working with ANR and hearing from a long list of stakeholders on how that rule should work. The rules for forest blocks are due to LCAR in June of 2026. And so the new criterion does not take effect until December 1, 2026. And then section 15 requires ANR to add to their mapping forest blocks and habitat connectors. So I feel like this is the section I usually get a lot of questions on about what does it mean to have a forest block? What does a forest block look like? How big is that? And all the details on that are spelled out in the rulemaking section, because there will need to be additional details on how all of this will work. And so the board is tasked with working with ANR and stakeholders to provide more clarity on where forest blocks and habitat connectors are located, and how applicants will know they're located in them. So what the public information on all that is. Section 16 is a sort of a specific provision. So this is lowering the amount of required mitigation for primary agricultural soils for wood products manufacturers from between 2 to 1 and 3 to 1 to 1 to 1. So under Act 250, criterion 9B, one of the 9 criterions, requires that if there are primary agricultural soils located on a site and they are going to be destroyed or converted, the project has to mitigate them by either conserving some of the soils or paying a fee to conserve other primary agricultural soils. And there's a formula in the statute for calculating how much the fee is. And this is lowering the fee if specifically for wood products manufacturers, which are not forestry operations. They're people who take logs out of forestry operations and turn them into things. Section 17 and 18 relate to accessory on-farm businesses. So section 17 amended the definition of accessory on-farm business, which until this point has been a a definition that is only used in municipal zoning. Under municipal zoning had to allow for accessory on-farm business if the business met the definition in the statute. They're allowed to do site plan review of the businesses to make sure it conforms with the other municipal zoning, but they can't fully deny it unless it doesn't meet the definition. Well, now this is changing the definition so that it allows the business to exceed the revenues of the farm, and it allows them to sell things other than the crops grown on the farm. They're now allowed to sell merchandise, baked goods, and agricultural products grown on other farms. Additionally, Section 18 created an Act 250 exemption for accessory on-farm businesses. So it exempts all businesses that are for accessory on-farm businesses that are related to the storage and sale of products. So your farm stand. But for processing and preparation of agricultural products like making jam or pies, there's an exemption only if 50% of the products are coming from the farm where the business is located. And there is no exemption for accessory on-farm business event spaces. All right, that is the first chunk of the bill related to a combination of Act 250 changes. We're moving faster than I thought we would. Any questions? Great. Okay. Next is the road rule. So as I mentioned before, this is creating a new jurisdictional trigger under Act 250 for the construction of private roads, at least 800 feet in length, or a combination of multiple private roads or driveways more than 2,000 feet in length. And this is starting July 1, 2026. And there are a lot of details in that statute about what it means to be constructing a road. And again, these are not municipal roads or roads constructed by the state. They're only private roads, and it doesn't apply to maintenance or repairs of roads, just construction of new roads.
Representative
Yeah.
Austin.
Is a road and driveway the same thing?
No.
Okay.
Yeah.
Yeah, okay.
And defining the distinction between them has been tricky in the past, but driveway generally leads to one house. But yes, I'll stop there. Yeah.
Representative North.
Does that include logging roads?
No, it does not. Roads use
Does that differentiates them? Because I can imagine on a private lot, you've got roads that might be.
Well, if there's-
Driveway and a logging.
That brings up the question, how do you distinguish a logging road from a skidder trail?
Well, luckily, the statute, we had many of these conversations at length. So that is one of the things that comes up when this happens. So the language that's used in the statute is a road used exclusively for farming or forestry purposes. But if that road then leads to, becomes a road used for residential use, it is no longer, so it is exempt if it's for exclusively for farming or forestry purposes. But once it becomes used for residential purposes, it is no longer exempt. There is a rulemaking associated with this as well, to clarify additional elements of this, because can be complicated to discuss all elements of the different types of road and the things that come up. But the road rule itself is 2 full pages, and so there is additional detail in the statute.
Representative
Can you go back over that a minute? I'm trying to make it make sense in my head. So you have somebody who's got a woodlot, but they have a home on it. And it's the road, driveway is gonna be used for multi-use. How is that defined? Is it driveway or logging road or private road?
So the language of the statute is on page 26 and 27 in the act. It is also in section 6001 in the statute. So it will depend, because this applies to roads constructed after July 1, 2026. And they are constructed by the private person, not the town. So it will depend in that, a lot of things will be dependent in that situation on that scenario. Because I guess it would depend on the geography, but if it's less than 800 feet in either case, it won't trigger it.
If it's longer. And then there's a log landing or two along that road. How does that affect it?
In what way?
Does
So-
it change the designation of what the road is called, a driveway or a logging road or something like that?
I don't know how much time we want to spend on the scenarios, because it really will be dependent on the site they are. Are they above 2,500 feet in elevation? It will depend. Which came first, the house or the woodlot? Because if you're, based on what it says here, if a road that was used for farming or forestry purposes is converted for residential purposes, it is no longer exempt. So probably, but I would need more detail, and this is something that they're gonna have to sort out, because it does get complicated in that way.
I'll probably try to catch up with you after this.
Oh, I'm sure that the board would actually love to talk to you. I don't necessarily want to keep talking about it.
Senator Pritchard.
Going back to forest blocks, so we had a thing earlier in forest blocks, and Fish and Wildlife. You said that it's A&R though. Are their forest blocks the same as the Fish and Wildlife's? Or are they the same?
So Fish and Wildlife is a part of A&R. And so the forest blocks for purposes of Act 250 haven't been mapped yet specifically. There's a definition of what it means to be a forest block, but it does direct the board, the Act 250 board, to work with A&R to clarify what that decision is and map them. So probably.
Yeah, because it looks like a lot of that's been done.
Yeah, it's just how those maps would be used in this context needs
Yeah.
to be defined.
Yeah.
Okay, location-based jurisdiction. So starting with section 21, 3-ish tiers have been created. There's tier 1, which is made up of tier 1A and tier 1B. There's tier 2 and there's tier 3. You can look at the definitions, but they won't help you too much because they do require additional detail. So tier 3 is areas consisting of critical natural resources, and that is going to be defined by the board. The board is going to do a rulemaking process that is in section 22 of the bill, and it directs the board to work with a long list of stakeholders and to look specifically at whether and how to protect river corridors, headwater streams, habitat connectors of statewide significance, riparian areas, Class A waters, natural communities, and other critical natural resource areas. So the board is going to start with those areas and then potentially include other rare and irreplaceable natural areas and define what areas constitute critical natural resources. And then those areas, any construction for commercial, industrial purpose or residential purpose will be subject to needing an Act 250 permit. On the opposite end of the spectrum are the tier 1 areas. The tier 1 areas, there is detail. Let's see, hold on. So just sticking on tier 3 for a second. As of January 1, 2025, the new board was to convene, and they probably haven't done it yet, but they'll be forgiven. They're going to need to convene the stakeholder group to start working on the board, start working on the rules. And then they need to file the proposed rules on tier 3 with LCAR February 2026. So giving them about a year before they have to get to LCAR. And the rulemaking is going to take months. So that might be a little bit close. But they're supposed to start work soon-ish on working with the stakeholders to review what are the critical natural resource areas.
Representative Tagliafico.
Can you give me an idea of the stakeholder groups?
Sure, it's on page, it is on page 31 of the bill. It shall include at least the regional planning commissions, environmental groups, science and ecological research organizations, woodland and forestry organizations, the Vermont Housing and Conservation Board, the Vermont Chamber of Commerce, the League of Cities and Towns, the Land Access and Opportunity Board, the State Natural Resources Conservation Council, and such additional stakeholders such as Vermont Ski Areas Association, the Division of Property and Valuation Review, the current use program, the Department of Forest Parks and Recreation, the Department of Environmental Conservation, the Department of Fish and Wildlife, the Vermont Woodlands Association, and the Professional Logging Contractors of the Northeast.
Everybody.
Or private landowners?
Additionally,
Personal?
no,
Purposes?
additionally, they shall seek input from municipalities and landowners that host critical natural resources on their property. Spent a long time on that list. So the opposite end of that spectrum is the tier 1 areas. So tier 1 areas are the areas that have been identified for development and growth, particularly around housing. And so I'll get into more information on that in a second. In the meantime, there's some additional exemptions sprinkled in section 24, 25, and 26. So section 24 extended an exemption from Act 47 of the prior year, which allows an exemption for the unlimited construction of priority housing projects located entirely within designated downtowns, neighborhood development areas, or growth centers, and within 1/2 mile around those areas, if there's zoning, and they have sewer, water, or soils advocate for wastewater disposal. So priority housing projects used to have a cap on the number of units that could be exempt from Act 250. These are priority housing projects are projects that contain a certain percentage of the units that are affordable. And so this is removing the cap until January 1, 2027. Additionally, it extended an exemption for the retail electricity utilities for the rebuilding of electric distribution lines. And so that exemption goes until December 1, 2030. Okay, next in section 27, section 6033 sets up the requirements for a tier 1B area. So tier 1B, I'll get to this in a moment, but if an area is considered tier 1B, it allows for an Act 250 exemption for up to 50 units of housing. So how the tier 1B process will work is that the regional planning commissions will be required to submit their regional plans and regional plan maps to the Land Use Review Board. They will have followed the new language for the requirements of the land use review for the regional plans and the maps that are in a later section of this bill. And as part of this, if a municipality requests, they will also identify which areas are eligible or will be considered tier 1B area. So the list of requirements for a tier 1B area are on page 35 if you're looking at the bill, the law, the act. So first, a municipality has to request, they have to affirmatively request that the regional planning commission identify this in their maps. The town has to have an approved town plan and planning process. They have to have adopted permanent zoning and subdivision bylaws. The area that will be tier 1B has to exclude flood hazard areas and fluvial erosion areas. except for those areas suitable for infill development. The municipality has to have a water supply, wastewater infrastructure, or soils that can accommodate community systems. And this municipality has to have municipal staff, municipal officials, or contracted capacity adequate to support the development review and zoning administration in that area. And in the next section, I'll talk more about what's required for tier A, but both tier 1A and tier 1B, it's removing the Act 250 oversight by in that process, ensuring that the town itself is doing municipal review of these projects. So currently, many projects, if a town has adopted zoning, many projects will need to go through the Act 250 process, but also the municipal zoning permit process. So the creation of tier 1A and tier 1B is acknowledging that a town has developed a zoning permit process that addresses many of the issues that Act 250 does, and so that projects can be exempt in those areas. So the Land Use Review Board is going to review whether or not the municipality has achieved the things listed, and if so, then the area of that town within that area will have an exemption for up to 50 units of housing in the tier 1B area. How'd I do? Yeah.
Great.
People are gonna come in here and put a graphic up and explain it better than I do, because I'm the words person.
Doing really well.
Okay.
I think we'll hear it again.
Yes.
From a different perspective, but this is really important for us because
Yes.
this is what we did as a legislature. Representative Bartholomew.
So, if town has no zoning, then none of this applies. That,
Correct.
okay.
Yeah. And so this is responding to the concern that in towns that have zoning, Act 250 may be duplicative. And so if a town doesn't have zoning, well, it's not duplicative, and perhaps some oversight of large construction projects is warranted.
So are they in some kind of tier at that point?
No, tier 3 are the critical resources. Tier A1 and tier 1 with its A and B are the areas that are identified for growth and development, but tier 2 is everything that isn't either tier 1 or tier 3. So it's everything in between. And the status quo Act 250 jurisdictional triggers will apply in those areas.
So zones 1 and A and B, you need to have zoning
Yes.
for all of it, okay.
And a subdivision bylaw.
Yeah.
I mean, it is important. They need to have both.
Yes.
At the time, it's part, they need to have both what?
Yeah, well, they need to have a subdivision bylaw in addition to the zoning bylaw. It's
Yeah.
it's often two different bylaws, but they need to have that covered.
Yeah, they can have it unified, but it's gotta be permanent because some towns adopt interim and then never fully adopt. So it's gotta be permanent zoning and subdivision bylaws, which I do sort of often shorten, but yes, it's permanent zoning and subdivision.
Representative North.
Didn't you also say and a town plan? If town plan, did I hear you say?
Yes, so any town that has zoning has to have a plan. The plan is the first step.
Who is it that does that approval of the town plan? Just the town
That's
itself?
a great question.
The regional planning commissions do.
RPC.
Yep. And so currently that, the municipal planning process is pretty well defined in Title 24. So a town has to adopt a town plan, and then it has to be, it doesn't have to be approved by the Regional Planning Commission. If they'd like to move forward, it does bring benefits if it is approved by the Regional Planning Commissions. And then any zoning that is adopted has to be grounded in the town plan. So they have to coordinate. They have to be based on each other. And then at the regional level, the regional planning commissions have adopted for the region a plan and a map. But until this next part, or until what I was just talking about, there hasn't been oversight of the regional plan confirming that it has followed all the statutory guidelines. So this is adding a layer of oversight to the Regional Planning Commission, which has some oversight of the town's planning process. So we're making sure everyone is at all times following the rules and that they all coordinate together. So that's tier 1B. the town itself is not making the application. They're just telling the regional planning commission, yes, we would like to be eligible. Please file with the land use review board as part of the regional planning process, our interest in having a tier 1B area because we meet these qualifications. And then the regional planning commission goes to the board, and the board issues the decision on the tier 1B area. Tier 1A area has more exemptions associated with it, so it's a different process.
Before you go, I just actually need to get so section 27 is the tier 1B section.
Yes, and it doesn't have it in the title, it just says regional plan.
A little,
Yes.
Representative Nor.
I just had a question because I've seen it a couple of places now where it says sewer, water, or appropriate soils. So does the or appropriate soils mean that you could put in a community septic system? Is that the intent there?
Yes.
Okay, so it's not necessarily restricted to town centers that have municipal sewer and water. Could be a tier 1A or 1B could be a place where there is no municipal sewer and water, as long as they're willing to put in a community level septic and well system.
That's correct.
Yeah. Yeah, and the town doesn't even have to install that community system.
The town.
No, they just have to have the soils that would be able to hold it, because the point here is that 50 units of housing is quite a lot. And so there has to be the ability for the developer to actually install a system that would be able to handle that type of development.
Could be 50 separate systems or one big system. But the soils, okay. Thank you. That's important.
Yep, so then section 28, this is the tier 1A area application process. So towns can start applying for tier 1A area status, which is a full exemption from Act 250. They can start applying for that January 1, 2026. But they also cannot apply until after the regional plan for their region has been approved. So it may or may not be January 1, 2026, but that's the earliest. So the legislative body of the municipality will apply to the land use review board. And it has to be an area of the municipality that is suitable for dense development and that meets all the requirements of this section. And it can be multiple non-contiguous areas. So a town can have multiple tier 1A areas. When they apply to the board has 45 days to issue a decision on the application. So the requirements for the tier 1A area are in pages 36 and 37 and onto 38 in Act 181. So they need to have a municipal plan. They need to have boundaries consistent with the downtown and village center and planned growth areas, which are part of the regional plan future land use maps. Further details on that are located farther into this bill, which we'll get into soon. But the regional plan has to identify that they are part of downtowns, village centers, or planned growth areas. They have to have adopted the flood hazard or river corridor bylaws for the entire municipality. They have to have adopted permanent zoning and subdivision bylaws that do not include broad exemptions or exclude large parts of the town from requiring a permit. They have to have permanent land use regulations that further the smart growth principles, that adequately regulate the physical form and scale of development, that provide reasonable provision for a portion of areas of the town with sewer and water to allow at least 4 stories. And they have to conform to any other guidelines established by the board in their application process. They have to be compatible with the character of historic districts and national historic sites or other significant cultural or natural resources. They have to have identified and planned for the maintenance of significant natural communities, rare, threatened, and endangered species located within the tier 1A area, or they have to exclude those from that area. So they have to have some kind of protection for the natural resources in their area. They have to have public water or wastewater systems or planned improvements that have capacity to support the additional development in tier 1A. So that is a distinction between tier 1A and tier 1B. And then they have to have the adequate municipal staff to perform the review. So then there's notice for the application, and there will be a hearing at the Land Use Review Board. The agencies will be notified that there has been an application. And yeah, the board has to issue its determination if they've met the requirements in writing within 45 days. The status will last for 8 years with a check-in after 4 years, and then they'll go from there. They can also, the board has the authority to, if for some reason the municipality changes its zoning or is not taking adequate steps to continue to meet the requirements of tier 1A, they can either require corrective action by the town or terminate the status. And then the Land Use Review Board is going to publish additional guidelines for the towns on what needs to be included in their application, specifically in what it means to have planned improvements for public water and wastewater. Those are due January 1, 2026. Section 30 requires the town to add their tier 1A and tier 1B areas to their town plans. And then section 31 is the big one. This is where all of the exemptions are located, primarily in this bill. So section 31, no permit or permit is section 31. Yes.
Yeah, going for about an hour.
Yeah.
And maybe it's time for us all to just take a break and help you
Mhm.
reorient. So we will take a 5-minute break